Good afternoon, everyone. Thank you so much for joining us today. My name is April Wepler, and I am the Communications and Engagement Coordinator at the Canadian Environmental Law Association, or CELA. And I'm going to start us off with just a land acknowledgement. So I am calling in today from Guelph on the banks of the Speed River. And that's in the historic boundaries of the Between the Lakes Purchase or Treaty 3 and Treaty Land of Mississaugas of the Credit First Nation. My role today will be supporting the webinar with any tech issues. So if at any point today you find that you are having difficulty with accessing sound or any other tech issues, feel free to message me in the chat box. So you will have that option to access the chat. If you have any questions through the webinar for any of our presenters, you're welcome to use the Q&A feature. So you should be able to click on the little Q&A box towards the bottom, and hopefully you're able to ask your questions in there. But as I said, if you have any tech issues, please feel free to use the chat. So on the line with me today are a couple of my colleagues from the Canadian Environmental Law Association. Teresa McClenahan is our Executive Director, and Julie Mutis is a community outreach worker working on our water files, as well as Priyanka Prasad, who is a law student working with CELA this summer. Also pleased to be joined by Ryan Bowie, who is the Associate Director with Chiefs of Ontario, and Kathleen Padulo, who is the Environment Director with Chiefs of Ontario. And I'll let them both introduce themselves when I pass the mic over to them in just a moment. Perhaps what I should have said off the top is the name of our webinar today is Protecting Water, Pathways to Drinking Water Protection in First Nations Community. We are recording today's session, so the recording will be sent out to you by email after the session and will also be available on CELA's website. We will be pausing the recording at the end of the presentations and not recording the discussion portion of the webinar. So following the presentations, there will be an opportunity to address questions that are in the Q&A box and have a bit of a conversation. And without further ado, I will pass the microphone over to Ryan and Kathleen and invite them to share their screen and start their presentation.
Hey, thanks, April. While Ryan's pulling up the screen, I'll just introduce myself. Good afternoon, everyone. My name is Kathleen Padulo. I'm the Director of Environment at the Chiefs of Ontario, and I'm happy to be here today. I'm just going to pass it over to Brian quickly so he can introduce himself, and then we'll start with our presentation. Thank you.
Brian Bowie, Associate Director of Environment at the Chiefs of Ontario, and happy to be here and interested to hear some feedback from everybody too. Thanks.
Okay, all right.
My screen's up okay? Everybody can see? Yeah, okay, thanks.
Okay, so Ryan, we'll just move on then to the next screen. So just to kind of put this all into context, the Chiefs of Ontario is an advocacy organization. We are not rights holders. We work with the rights holders. And our mandate is to ensure that we're communicating and advocating on behalf of, with the First Nations, directly related to their mandates that come from resolutions in the Chiefs Assembly. So I'm going to start with some of the work that the Chiefs of Ontario has done with Human Rights Watch. And important to know that in 2016, Human Rights Watch came to the Assembly of First Nations and to Canada. We're trying to understand and looking at why there is a water crisis in First Nation communities and what they could do to help. And so Human Rights Watch spent a couple of years researching the work in their document called Make It Safe, Canada's Obligation to End the First Nations Water Crisis. And out of that Human Rights Watch report, there were a number of recommendations. And so what I've done here is just listed 3 recommendations related to source water, because that's what we're talking about today. And so those recommendations are still in place. The Government of Canada, this recommendation was to establish an independent First Nations Water Commission. And this Water Commission is mentioned in the water legislation, Bill C-61. And the purpose would be to monitor performance related to water and wastewater on First Nations. lands, but really taking into account First Nations laws, customs, and practices, which is very unique. Then we have INAC, which is now ISK. And one of the key recommendations here was working with First Nations to ensure that new systems designs are developed that would allow for population growth and the life cycle cost of infrastructure and adapting to decreased source water quality over time. And for the government of Ontario, it was to develop robust intergovernmental mechanisms with federal and First Nations for sharing expertise and traditional knowledge specific to water as it pertains to source water protection and water and wastewater infrastructure. And a lot of this came out of the Walkerton inquiry, which I know Celia will go into in further detail. But some of the other recommendations within the Human Rights Watch um, uh, research paper was not just to Canada, it was to the Parliament of Canada, it was to Health Canada, it was also to tribal councils, and of course the government of Ontario. So we can move on from that, Ryan. Thanks. So I wanted to spend a little bit of time discussing the water declaration. And it's important also to honor the late Josephine and all of the work that she was instrumental for in bringing about that, not just the connection to water, but getting people to go to the water and understand the significance that water is life. And so the Chiefs of Ontario in, I believe it was 2009, we responded to the policies that were being developed without First Nations. We responded to Ontario and the federal government's policies with a water declaration. And we continue to use this as a foundation for our decision making and the work moving forward. And really, the water declaration speaks to those responsibilities that we have as First Nations to the water quality, quantity, safe drinking water, our traditional ecological knowledge, and Great Lakes governance and restoration. And, you know, I really think that not only does this responsibility land with First Nations, but it is the responsibility of everyone moving forward with source water protection. Next, Ryan.
Yeah, so I'm going to talk a little bit about just the provincial government there. As Kathleen just mentioned, too, with the water declaration, it was put forth because of lack of progress working through both provincial and federal governments. But the province, they've been consistently lacking in support for source water protection for First Nations, and that has only grow more apparent with Bill 5. And because those regulations, they give significant decision-making powers to ministers, uh, particularly this creation of special economic zones where ministers can designate trusted proponents and designated projects that are then exempt from certain provincial and municipal permits, environmental assessments, other laws. And what's concerning, particularly concerning about that is that if they need these kind of powers, it's because they want to override environmental protections, and that makes your source water even more vulnerable. Um, it also creates a lot of cloud and mistrust uh, amongst First Nations communities about what the priorities of the federal government are or provincial government are. What are they planning to go forward with? And the multitude of projects that could possibly be involved in these zones there are can be pretty significant impacts. We know that they've talked about that in the context of the Dresden landfill. There's significant quarry work that has particular impacts, and certainly in the north of Ontario with the Ring of Fire and other mining projects, critical minerals that are all the rage right now. There's a lot of uncertainty for source water protection. in that environment. And yeah, that doesn't, it's not just for First Nations, that's for everybody involved. Um, and what's also particularly concerning is that with the federal clean water legislation, Bill C-61, the province of Ontario, along with Alberta, communicated to the federal government that they were opposed to the source water protection measures that are contained in that legislation and did not want that legislation to go forward. And a statement like that is kind of hard to wrap your head around that they're actually advocating against safe drinking water for First Nations in that context. And so we are quite concerned with federal activities there. Um, yeah, and it's all in the name of not hindering developed projects, and that pressure is both provincial and federally are quite extreme right now. So Kathleen then is going to talk next on the background to some the drivers for federal action on safe drinking water.
Okay, so this is important to understand in the context of Bill C-61. So the First Nations Class Water Settlement Agreement came out, the announcement came out December 2021. And First Nations won a settlement agreement. And the terms of the class action settlement agreement also related to repealing the then Safe Drinking Water for First Nations Act and replacing it with the new legislation and consultation, and to have this completed by December 2022. So a lot of work and advocacy went into working with Canada on this new legislation. What's important about the class settlement agreement is not only did it pave the way for the new legislation to be introduced, but also provided funding to individual First Nations who were who were living in a First Nation community on a boil water from 1995 to 2021. And so there was funding set aside for that. But the important part also has to do with the funding set aside for safe drinking water on reserves. And that is a minimum of $6 billion. And also there was a creation out of that settlement agreement, 400 million for First Nations Economic and Cultural Restoration Fund, and the creation of a First Nations Advisory Committee on Safe Drinking Water, made up of First Nations, working with the lawyers from the Water Settlement Agreement and overseeing and advocating to Canada to honor the agreement. So we continue to advocate to Canada to honor the agreement. Ontario continues to have the highest number of long-term drinking water advisories, and really we're pushing Canada to do the right thing here and follow through with the class action water settlement agreement. Next slide. And so some of the advocacy work that we continue to do, even though the Bill C-61 was prorogued when Justin Trudeau stepped down, what we have been working on is continuing with our mandate from the chiefs for the urgent implementation of the settlement agreement and the legislation. And so we have been holding press conferences. We have been putting out op-eds and working with a lot of, I would consider our partners like CELA, in clearly communicating the need for federal legislation for First Nations on reserves. Okay, next slide.
So yeah, so I'll talk a bit about Bill C-61. Apologies, my neighbor just started working power tools next door, so let me know if you can hear that coming through the mic. Okay. um, yeah, so with Bill C-61, then, as Kathleen mentioned, that this legislation was uh, introduced as part of the water settlement agreement requirements. And for Bill C-61 in its drafting, it was a long and rocky road, but First Nations were highly involved in the drafting of the legislation. Uh, we're able to meet and see drafts prior to introduction to the House comment, and those comments incorporated into the final legislation. That is the first time that has ever happened. Landmark for that, and a pretty significant accomplishment, and very challenging across Canada. Lots of First Nations communities, organizations, and support in making that work. Um, And with Bill C-61, the First Nations Clean Water Act, it aims to establish like federal regulatory framework for water services and supports source water protection. It provides um, onus on the federal government to fund those. It doesn't spell what that funding will be, but it needs to be adequate to the job. Um, and it recognizes the human right to water in that legislation. Um, and prior to his election, Prime Minister Carney, he emphasized that the implementation of the United Nations Declarations on the Rights of Indigenous Peoples is fundamental and unwavering, and also noted that Bill 61 aligns with this commitment by addressing the long-standing water infrastructure issues. Um, However, since that time, since prorogation and the election, there have been no updates provided by Indigenous Service Canada. Uh, Minister Galmasti verbally confirmed that introduction legislation would occur, but they have also indicated that there may be amendments to this legislation. And that is not something that we want to accept because of all the efforts that were put into this in the first place. It went through committee. It's been highly vetted already. Uh, and so Golmassi's comments are concerning in that context. And so we have a mandate from the chiefs in assembly to advocate for this bill to be reintroduced unchanged to ensure sustainable funding for water and wastewater infrastructure. Uh, we've heard the commitment from the federal government for a spring 2026 timeline for reintroduction. That is fast running out of track before the government breaks for the summer. Maybe they're planning on reintroducing it on the last day. But we don't know. We've not had any updates, as I mentioned. Um, Prime Minister Carney, who addressed the Assembly of First Nations in December, I think it was, he called for that first ministers' meeting where First Nations would set the agenda. So, meeting with the federal government and all the First Ministers at the provincial level. Um, that work has been ongoing and to work out what that agenda might look like, and that's expected to happen in the fall. But without this legislation, we're unable to close the gap in drinking water and wastewater services. Boil water advisories in Ontario form the bulk of the issues across the nation. And yeah, and so we're still working in this complete regulatory limbo for source water protection and drinking water infrastructure for First Nations. Um, Yeah, and with the prorogation with that killed the bill in the first place, that continues that problem. It's not living up to the water settlement agreement. It's not living up to the standards of human rights to water, and First Nations leadership remains quite concerned about this. And I'll flip it over to Kathleen to close.
Okay, thank you for that, Ryan. That was great. I think, there's a lot of issues that we still need to advocate and push government to do the right thing. But I just wanted to let folks know that Ontario has more First Nations water systems that rely on surface water and groundwater under the direct influence of surface water. So this means that out of 158 community water systems in Ontario, 107 rely on surface water. And in these communities, water quality is directly related to watershed and source water conditions. And so it is highly, highly relevant that, federal legislation be passed tomorrow so First Nations can have the same human rights as everyone else, safe potable drinking water. Thank you.
Thank you, Kathleen. Thank you, Ryan. That was
Thanks.
all very, very well said. Great context, and very clear messaging. Thank you for that. Um, Anything else to add, or do you want to take your presentation down, Ryan, and I can pass? Perfect. Okay. So Teresa, if you want to go ahead and put your presentation up, we'll shift over to you. And just a reminder while you're doing that, if you have any questions during the presentations, please feel free to put those in the Q&A box.
Yep, and just give me a second to go back and start from the beginning. There we go. Okay, I think that's sharing.
Yep, that's great.
April's nodding. Thank you. Thank you, everyone, for attending today. And thank you to Kathleen and Ryan and the rest of your team as well for your incredible advocacy on behalf of your member nations. CELA has been working on drinking water safety for decades. We're a specialty legal aid clinic. We do representation, could be individuals, groups, First Nations, no for-profit entities, no corporations. And we also have a related foundation where you can find a lot of the history of our work, including briefs and submissions over the years. And we also provide outreach and education. So I'm going to position this in contrast to municipalities, and I will get into Walkerton in a second. But sorry, I think I went too far here. There we go. So for over 20 years now, actually probably about 24 years, Ontario municipal drinking water has the benefit of what we call a multi-barrier approach to protecting drinking water, which means we'll get into source in a moment, but after source water, there are also binding standards, there are trained operators, there's testing, there's a way to tell people if their water is unsafe, a way to rectify that, and so on. But most First Nations with drinking water systems don't yet have access to a full multi-barrier approach. And we are at CELA extremely concerned about that and have been for decades and decades. Justice O'Connor headed up an inquiry to the causes of a tragedy that occurred in Walkerton, Ontario in the year 2000, where 7 people died from drinking unsafe water that was supposedly treated. And it was a failure of multiple levels of protection. And in the second part of the inquiry report, which was talking about how to prevent problems and repeat of this tragedy in the future, he devoted a chapter to First Nations drinking water quality. And he said it's not acceptable that, and this is straight from the report, water provided to many Métis and non-status Indian communities and to First Nations reserves is some of the poorest quality water in the province. And so here we are 26 years after that tragedy. And by the way, there was a companion inquiry occurring in Saskatchewan at the very same time, which arrived at pretty much identical conclusions. But here we are, and we still don't have this addressed. So what he said in his report about First Nations water is that Ontario First Nations should be invited to join watershed planning process. And I'll say more about watershed planning in a moment. but basically to be part of how all of the water in a watershed that flows across the same landscape and through the same subsurfaces is connected and can be protected in a systematic and holistic way. He also talked about First Nations and the federal government should formally adopt some drinking water standards as stringent or more stringent than the province, because why would it be acceptable for it to be any less? He recommended a quality management standard, also that the Ontario Clean Water Agency, which is an Ontario held corporation, provides services, offer services to First Nations when needed and as needed and with appropriate arrangements, and that provincial government should offer its training facilities and technical assistance to First Nations operators on a cost recovery basis if requested. And some of that has happened. There has been some assistance from Aqua in some places. There's a training center in Walkerton now, and there has been some training provision for First Nations specifically. So I talked about this earlier. What is a multi-barrier approach? So it's a way of thinking about our water. And, people in the water industry said to me one time, something that really stayed with me, water is the best solvent on the planet. It just picks up everything that it goes through, that it comes into contact with. So you first have to protect that source of water, as well as worry about your treatment and your system and your emergency response. And that way, unlike the Walkerton tragedy, if one barrier failed, there'd still be something to protect the population and ensure safe water despite that failure. Um, and Justice O'Connor, in his report, talked about source water protection in about a third of his recommendations, which is amazing because at the beginning of the inquiry, before Sela and our clients, the concerned Walkerton citizens, started talking about source water protection, the inquiry council and experts didn't know about source water protection. It wasn't on their agenda at all. And by the end of the inquiry, a third of the recommendations are about protecting source water. And so common threats that we often see, both municipality, rural, and would be relevant to many, many First Nations, particularly in Southern Ontario, but also Northern Ontario for some of these, would be related to sewage disposal, which could be, either the outflow of a treatment plant or lagoons, for example. Manure was the source of the Walkerton tragedy. That remains an issue if not appropriately managed. Industrial waste, for example, being applied to farmland or just not being properly controlled, leaks from fuel or pesticide storage, other chemicals. So you don't want these threats into the source of the water. It can be very difficult or sometimes not even possible to treat it and then provide safe water once it's there. Um, so after the Walkerton tragedy, there were a variety of advisory committees, which Chiefs of Ontario participated in, as did Sela, about how to establish a framework for source water protection as the first barrier. And Ontario adopted a law in 2006 to put this in place. And what it does is it maps the sources of municipal drinking water, whether they're surface water or groundwater, and it maps the pathways of potential contaminants if they were at the surface or if they were coming through pathways through the subsurface. It sets up some priorities for which threats would be worst, the hardest to manage, the most damaging to health. And then in each area under this legislation, each geographical area, a binding plan is recommended and then approved by the province to ensure protection from those threats. And so here's a diagram from uh, Source to Tap, which was a report on source water protection about the essential pieces. So it's a science-based approach, but it's tailored to each location. As mentioned, it's far cheaper to keep contaminants out than to try to deal with them afterward, if you even can. Sometimes it literally means moving the source and the intake and all the infrastructure associated with it. Um, and then it makes sure that there are mechanisms um, to respond specific to the threats. So if you're in one place, maybe the mechanism is a septic tank inspection program to make sure that, septic tanks are all properly constructed and uh, or in other cases, actually, there have been well inspection programs to make sure that people's wells within that aquifer have proper casings. In other places, it has to do with land use controls, not allowing something like manure spreading right within the high close time of travel to a groundwater system. So the proposal that Kathleen and Ryan have been talking about uh, established that there should be clean water, safe water for First Nations. And its purpose outlines that there should be safe water achieving the highest standards of health, safety, and well-being, not an afterthought. It affirmed the inherent right of First Nations to self-government and their jurisdiction in relation to water, source water, drinking water, and ensuring consistency with Section 35 and with UNDRIP. So there are some possibilities that First Nations can take, and this is partly what we're talking about here today in this workshop, to protecting sources of drinking water. As you'll see at the end, we strongly advocate for the introduction of the new legislation as a way to get us the rest of the way. But we'll talk about these as we go through for a couple of minutes. So people could pursue and exercise existing treaty rights, Aboriginal rights, as protected by Section 35. They could use federal legislation that exists today for band council resolutions or land management. They could opt into the provincial source water regime, which I'm going to take another try persuading some of you to consider over and above the three who have so far. And of course, absolutely important is the introduction of new federal legislation co-developed with First Nations. So many First Nations in Canada, of course, already have inherent jurisdiction that does not depend on federal statute and exercise that. And we have another workshop we did quite some time ago on that topic. This was based on master's constitutional law research I did a long time ago, and have been encouraging that approach ever since. Under federal legislation, there also can be bylaws that can be useful, and CELA worked with a number of First Nations in Ontario with some various sources of foundation funding to work on illustrating those, and they consulted with their communities as to the ones that could be acceptable to pursue. And so those could still be done for sure. They could still be useful today, even without a systemic federal statutory response that could still provide some assistance. And we have a toolkit there that gives examples of those and some of the ones people had really prioritized in our discussions with those First Nations communities. So well regulation, land use control, wildlife conservation, rules around hunt camps, and so forth. Also, there's the possibility of band council resolutions around short-term situations, like a relatively urgent situation dealing with storage tanks, for example. So those are all available and possible options. Land management is another possibility, and some First Nations have developed land codes through a community approval process. And I believe in the toolkit that we reference, we also gave links to some of those that were in place across the country at that time. And this can deal as well with some enforcement powers in addition to land use rules. And land use, by the way, in the Ontario's Clean Water Act, which is our source water legislation, land use is a really, really key tool. The big gap that we noticed when we were trying to implement source water in the province for municipalities is that historically a lot of leeway has been given to people around their existing and past land uses. And the normal municipal laws and zoning laws don't change that. They're always, quote, grandfathered. Um, so what source water protection did is it gave the power to the province, municipality, conservation authorities, the source protection committees to say, no, you cannot keep doing that activity in this place. We don't care if you did it for a long time because it's too much of a threat to safe drinking water. So it is an important tool. So the Clean Water Act, which I just mentioned, was adopted in 2006, and it does have, so while it primarily focuses on municipalities and it's got ways to deal with non-municipal systems, which is a whole seminar on another day, um, it does allow First Nations to opt in to source water planning um, if the source water planning area includes that First Nation. So for Southern Ontario, there are quite a few where that could be possible. That legislation, and I should disclose, I took a secondment to go work for the minister's office for 2 years to help pass this legislation. And this clause that was added during committee consideration about non-derogation means that existing Aboriginal and treaty rights are not impacted negatively or at all if a First Nation opts into the Clean Water Act. But a resolution is needed to participate. The province won't impose this on any First Nation, municipality, conservation authority, et cetera, will not impose it. It needs to be the First Nation's request. However, as we note here, it doesn't clearly sort out how funding issues that might relate to threats assessment and implementation would be handled. Um, which is where the First Nation, the federal legislation C61 would have helped quite a lot with the cooperative approach that it espouses. Um, so some of the catchphrases from the Clean Water Act, it's locally driven, it's science-based, it's consultative. They have committees that cross all kinds of sectors from land use, industrial, forest management, aggregate, um, agricultural, public interest, wilderness, all kinds of perspectives come together. And they collectively soon grow to realize that they're all in this together with this common objective of safe water. So once the source protection is approved, then there's quite a bit more um, strength in what can be done. So especially for the highest priority threats, and certain measures or protective measures that become binding, then the province can't issue a permit to somebody that contravenes that approved source protection plan and thereby threaten the sources of water covered by it for municipalities or those First Nations who've opted in. Similarly with municipal action, land use decision making, etc. And even private landowners' actions are controlled through risk management systems that could require them, for example, not to carry out an activity on a certain part of their land. So how it's done is by initiation by resolution, and then the province has the authority to implement all of these binding tools that I just mentioned. So as I alluded to, only 3 First Nations have opted into this system so far. Some have considered that because it's provincial legislation, they would not like to formally opt into it. Um, and then other First Nations are outside of the boundaries that were drawn in that provincial legislation in terms of source water protection boundaries because they more or less coincided with conservation authority boundaries, which of course have just changed. However, the source protection authority boundaries still remain in place today, despite that recent change to the Conservation Authorities Act. So with work we've done in the past, so we did this. This is a picture with Chippewas of the Thames First Nation, uh, Oneida, and Munsee, Delaware, the Tri-Nations. We did one of our projects with them, and there was technical support from University of Western Ontario and extensive involvement by the community to talk about historic land uses, what threats people were aware of, what they were aware of that others outside of the community had done in the past, neighboring landowners and industries, developed with a plan and then adopted an approach. Um, so we did these three of these projects across Ontario a fair while ago now, 10 years ago, and it was really obvious that the community needs to be integrally involved in them, both because of their knowledge of the whole watershed past use and also in terms of supporting the actions to be taken and prioritizing the threats to address. So those are available, and as April said, you'll get this slide deck and these links. And so to circle back to the federal bill, we too are extremely concerned that it fell when Parliament prorogued and are calling for the federal government to reintroduce it in the format that had been reported out of standing committee. And we wrote to the Prime Minister, and then we wrote as here to the Minister, calling on the federal government, and especially because our role all along on this legislation has really been to emphasize the source water piece, emphasizing how important that is. And as I mentioned, there are some really important provisions that were included in that bill that really are quite significant and groundbreaking and could make a huge difference for the ability of First Nations to really truly protect their water. And some of the language that was included is quite important. It echoed the multi-barrier approach and the protection of source water. And I think also, it would give new momentum to protecting these systems. If we had the legislation, we could go back to in Ontario, some of the existing systems and look at how things can include First Nations and be adapted in Southern Ontario and then outside of those boundaries of existing source protection to get new protections on the ground around source water and then the rest of the system for safe water in those communities. So we do encourage you to reach out to Ontario's Environment Minister, McCarthy, to encourage Ontario to be supportive, but especially to the federal minister in whose shop this lies, to get this bill introduced. And as we were just discussing offline, spring is almost over. So we really think this needs to be treated urgently, and we think it's really important for the federal government to be hearing from lots of voices, both within and outside of First Nations. And that submission will be linked when you get this deck as well. So that is it for us, and I will turn it back to April.
Thanks very much, Teresa. Excuse me. Thank you very much for that presentation. That was really great information. I'm going to pause for a moment before I move us to discussion for two things. First is just to let folks know there is a survey that I will be speaking to in much greater detail in a little bit, but I know sometimes people are double booked. We have lots of commitments, so I'm going to drop the survey link in the chat box just on the off chance that you have to step off early. That will be circulated along with the recording and the slides via email later this week or early next week as well, but putting that in the chat right now. As I said, I'll give more context later. I am also going to stop the recording in just a moment. So for the sake of the recording, I do want to thank our presenters very much for their presentations, and especially thank you to Kathleen and Ryan for taking the time to both prepare and deliver that presentation. We know you have a lot of demands on your time, and we appreciate you taking the time to be with us today.